Hello all, welcome back to this seventh lecture on industrial relations and labor laws. In this video, we'll be discussing about the various industrial disputes. We'll be taking over from where we have left in the previous video. So what is the scope of this video? Let me discuss. Firstly, we'll be looking at the various industrial disputes and the probable MCQ questions based on what could be the causes for this industrial disputes, basically a theoretical subject. We will be discussing how participation of workers in management of labor, which is a concurrent subject, happens, and what is the historical evolution. Certain multiple choice questions can be asked from this area as well. We'll be discussing about that. The next aspect is whether trade unions have a fundamental right to strike. What is the recent Ordnance Factory Board case? We'll be dealing with that as well. And most importantly, we'll be dealing with a concept called collective bargaining, which is a methodology or a form of participation of workers in management to resolve industrial disputes. So, this is the scope of this video. Firstly, worker participation is a part of the directive principles of state policy as per Article 43A. So, what it implies is state wishes to create such laws where workers are participating and creates an industrial democracy. You have to remember that whenever we're talking about industrial democracy, it is not like their decisions are binding on the management. Ultimately, it is all about finding that balance between those who are providing employment and safeguarding the rights of those who are working for them. So, in this context, when we are trying to define the nature of participation of the workers in any democracy, industrial democracy, Amartya Sen has classified three different kinds of styles of worker participation. So, first one is just a namesake sort of a thing, that is superficial. In this kind of participation style, you just witness certain sharing of information about how company is running. So it's just a namesake kind of a management style. Second thing is about intermediate style. So this is where you will witness the concept of collective bargaining, which we'll be discussing further. The next one is the real participation or financial participation, where workers are made partners in decision making. So this is something that you are witnessing a lot in this startup ecosystem. You give them a share of your company and make them stick to your company, because that is what these tech-based startups are witnessing in the recent times, just to retain talented employees. We will be looking at one after the other from MCQ perspective alone. So you can just classify the information given here, and each of them could be a method of asking MCQ questions. So just pay attention. The next thing that we have to note is what are the levels of worker participation and what are the different forms. So when we are talking about levels, basically when you're talking about workers, they can organize themselves at the unit level or the plant level, unit level or plant level. Basically, it means that even if there is a factory, say for example, Tata has multiple factories, or any company has multiple factories across the country. So when we're talking about a plant level, it only means that other branches are not affected or other manufacturing plants are not affected by this issue. So when workers organize themselves at the unit level or plant level, the possible body that you can witness is called work committee. Please remember, work committee is at the unit or plant level. When it is at the industry level, then it is called an industrial committee. What is the difference between an industry and a unit? So basically, Tata Motors is, or let's say Tata is producing one car. Similarly, you have Maruti, Hyundai, etc., who are equally competing within the industry of automobiles. So that automobiles is together considered to be an industry. So when there are concerns regarding the safety or any disputes arising because of the structural deficiencies within an industry, then you have industrial committees handling that issues. But when it is on a regional level, then you have the state labor advisory board. If it is at a national level, the central government will come into the picture. But when it is at a global level, you have the International Labour Organization. So these are the levels of worker participation. You just have to know. There can be a MCQ question from any of this as well. Now, what are the various forms? This is the next possible area. Like already discussed, the most simplest form is the work committee that you can witness at the plant or unit level. So all the industrial level, regional level, and national level can come together in collective bargaining concept, which we'll be discussing. And then suggestion schemes. So we have seen how Amartya Sen has classified various methodologies of worker participation. So you can classify this as a type of superficial participation where the workers' suggestions are heard, but they are not necessarily followed. The next thing is quality circles. So important point you have to note in this case is they are voluntary in nature. So in order to ensure quality within the company or within the plant level, workers come together just to ensure that quality of work is there. And this concept has its origin in Japan. You can expect a question on this as well. And the next thing that we have talked about is the real kind of participation or the financial participation, where the company offers certain stock options to the employees and it is called employee stock option. So this is an example of real or financial participation. So a trivial fact, the first PSU which took this ESOPs route, employee stock options are also called ESOPs. So it is NALCO. NALCO is the first PSU which took this option. And this ESOPs as a concept became very famous from the time of Infosys and its dawn in India. So these are the points you have to note. Now let us understand what exactly is an industrial dispute. In the previous videos and also in the first video of this lecture series, we have discussed how industrial relations is all about the three parties involved or the tripartite agreement between various stakeholders involved. So you have trade unions, workers, and management or employer. So one might wonder how exactly is a trade union different from a worker? This is the concept where you have to understand trade union is a structure created by the government to deal with the industrial disputes. So by legislating this industrial relation code, what it is doing is it is legitimizing the ability of workers to let their grievances know to the management. So in the first video, we've discussed how this is a tripartite model. So in the tripartite model, you have the worker, employee, and the government. Now, government cannot always come into the picture whenever there is a conflict. So as a proxy, what government will do is create a structure where trade unions are run on the basis of the laws created by this government as a proxy. So in a way, we can say trade unions are representatives of the government, or rather we can say the government has legitimized this trade unions and gave them this bargaining power. So in its simplest definition, what we can say is industrial relations is all about conflict management. By creating a code, what it does is it defines the scope of the actions that each stakeholder can take against each other so that the damage that they can do to each other is minimized. Say, for example, if the workers want to carry out a strike, it should not hamper the productivity of the company. Similarly, if the employer decides to lock out all the employees and say it exhibits a dictatorial attitude whenever there is a grievance, even that is not a healthy scenario. So this is the necessity for creation of industrial relations code. Previously there were various laws which we have discussed in the previous video. Now we are just trying to understand the various questions that can come from the topics of this code. So we can say that the government has legitimized this trade unions. So it created an institutional mechanism. At what level? One, the plant level; two, the industry level; and three, the national level. So we have discussed that this industrial relation code is all about giving industrial democracy to the workers. So it sort of creates a framework for communication systems to discuss about issues like what can be the wage, what can be the methodology of expressing one's grievance, what is the importance of the power of vote in a trade union or the sanctity of the ballot, and finally what are the mechanisms for this tripartite negotiations, or what are the laws or legal methods to ensure that all this communication is actually enforced. So these are the points that you have to note. So there can be MCQs on this as well. Which of the following is a priority of the creation of industrial relation code? You can just eliminate the option which seems very odd. So previously we have had this industrial disputes as a subject matter in the Industrial Disputes Act of 1947. Now we have subsumed that under the Industrial Relation Code of 2020. In this code, we have updated the definition and clearly laid down what additional avenues can also be addressed by this law. So, if an employee is discharged by the company or the employer, or if he is dismissed, retrenched, or terminated, and if it does not happen as per the process laid down in this law, even then it is considered to be an industrial dispute. Now, one might find a bit of confusion about what termination, retrenchment, and layoff actually means. We have discussed in the previous videos, but again, let me clarify. Basically, termination means stopping this payment or stopping taking the service of an employee. Now, this can be of two types. One can be retrenchment, and the other one can be layoff. And there can again be third kind where the company removes him because of misconduct. Each of this is different. If you take the termination as a larger circle, retrenchment is a special case of termination where it is permanent in nature. Now, one has to remember that if the contract or fixed term employment, like we've discussed in the previous video, ends, it does not mean the company has retrenched him. So, any provisions that are related to the retrenchment of an employee is not considering this contract, because it is as per the predetermined contract itself the services are terminated. And whenever we're talking about layoff, it is temporary in nature because let's say, for example, the case of COVID. Because of COVID, the company decides that we have to cut down our workforce or stop our production. So the company gives a notice of layoff to the employees and says, we will call you back when the activity is back to normal. That is layoff. It is temporary in nature. Now, it is very common knowledge that industrial disputes occur because, one, on a psychological basis, if the mental health or the psychological satisfaction of an employee is not taken care, it can ultimately go out of hand and create an industrial dispute, because ultimately it is all about emotions when we're dealing with people. So that can sometimes spill over and create an industrial dispute. Second one is about social needs. If you are being insensitive about the social needs of all the stakeholders, even then you can expect the industrial disputes to take place. And the third is the most important thing: when legal rights of either of the stakeholders are not respected, you can expect industrial disputes. So they can be of two kinds: one, the collective, and two, the individual. So if you say you have to increase the salary, that cannot be individual. But if your salary is not paid on time, then it is an individual problem. What is a collective problem? If, see, for example, a class of workers, say everyone below 18,000 are considered to be workers as per the definition, right? So for a particular set of employees, the salary is fixed at 18,000, and if one out of that 300 people comes out and says I want 20,000, that is simply noise, because it does not have any legal sanction. If 300, or at least a majority of them, believes that there should be an increase in this wage from 18,000 to 20 or 25,000, then that can become a collective issue, and anything with respect to wages can be collectively bargained. Bonus, profits, anything, profit sharing, anything can be a collective bargain. So these are the two types of industrial disputes. Now, whether a trade union has a fundamental right to strike? No. This is the recent Supreme Court judgment, just reiterating what it previously in various cases also said the same thing. One has to remember that this right to strike may not be a fundamental strike, but it is a legal right. Under which act? Trade Union Act of 1926, not the Industrial Dispute Act of 1947 previously. So UPSC EPFO exam can have questions from the olden laws as well as a comparative question. So please remember this point. Now, why is it important to have a strike? Obviously, to let the employer know about the grievances. But at the same time, ease of doing business should not be affected. There is a need to maintain that balance. That is why there are certain reasonable restrictions. Now, what are certain important cases in this context which reiterated this reasonable restrictions on workers? It is the All India Bank Employee Association versus IT. This case said that right to strike, of course, comes from the fundamental right of right to form associations, but the reasonable restrictions on it stops it from making a fundamental right. So, right to strike is not fundamental. Recently, the government decided to uh, corporatize the ordnance factory boards, and the employee unions there decided to strike. In that context, the Supreme Court observed that essential workers should not resort to strike, or those workers who are involved in public activities, they cannot carry out strikes. So, in this context, you also have to remember when you are registering the trade union, it will be registered as something called body corporate. That is to say, even if the people who are manning that particular organization come and go, this will always remain intact. That is to say, this is a permanent body. Just like how governments come and go, or the people in the government come and go, but the government as such remains just like that. There is a continuity of the decisions taken. Trade unions are also like that, and hence they are called body corporate. So for that reason, there are certain exceptions, and certain acts are not applicable to trade unions which are registered. Now we have discussed about the registration process of a trade union and all those details in the previous video. If you haven't watched it, please go back and watch it. What are the acts which are not applicable? Again, this can be a probable question. Society Registration Act of 1860, Cooperative Society Act of 1912, Multi-State Cooperative Societies Act of 2002, and Companies Act of 2013. Which of the following is an act which is not applicable to trade union? You can have 1, 2, 3, 4, and the question follows. Previously, if rules were followed as per the Industrial Dispute Act of 1947, it was considered to be a valid strike. So what are those rules? We'll be just discussing, but before that, you have to remember an important point, again important from MCQ perspective. The previous Industrial Dispute Act of 1947, this was applied only for public utility services. What does it mean? So this means that medical staff or school workers like teachers, the non-teaching staff, or any governmental service which are considered to be essential, like say for example police or fire department, all these are within the ambit of the definition of public utility service. Back then, the economy was oriented towards a socialistic pattern of society where workers were given a priority and businesses were often looked with suspicion. So, naturally, this strike and other activities were considered to be the rights of laborers, and there has been a constant tussle between the industry as well as the workers, and this has hampered our image because of the inconsistencies within the labor laws. Labor law compliance also became very difficult for companies, and at the same time, there are certain companies which have used these loopholes and exploited the workers. So, either way, it was hurting the laborers as well as the economy. So, in order to correct that, we have to just enforce the existing procedure and extrapolate it to all the companies, not just certain companies, because like we have discussed, there are certain companies which are exploiting the services of workers. You have to stop that, and at the same time bring about a uniformity in the law. So now what this new code did was, all the workers in all the industries can participate in a strike. So what is the process? Firstly, the notice will be given, and this notice, like discussed in the previous video, is 6 weeks previously. Now it is 60 days. After the notice, 14 days before the notified date, you cannot carry out a strike. And as soon as you give the notice, obviously you will start an conciliation proceedings. That is, you try to amend the discrepancies within the issue by sitting with the management and trying to reconcile with them. So when this process is going on, if say for example X is the date on which this conciliation process ends, so till the end of seventh day from this X, one cannot begin a strike, and of course before expiry of the end date of strike as per the notice. So these are the common provisions for 1947 Industrial Dispute Act and the present code. This present code gave a new addition, that is, if there is a arbitration that is going on, if the arbitration process has begun when the conciliation did not actually take off, then after the end of that arbitration proceedings, you have to give the management a time period of 60 days. This is the new addition as per the law. So if this process is not followed, then that strike is considered to be invalid. Similarly, lockdown is the reverse case where employer is actually shutting down employees for whatsoever reason. Now, the same lockdown provisions, the process involved, is applicable now to all the industries. Previously, it was just for public utility services, like already discussed. Now we'll be looking at certain types of strikes. Again, this can be asked from the MCQ perspective. So what are the different types of strikes? Economic, that is for economic grievances, self-understood. Sympathetic strike, to show solidarity to other companies. Say for example, if Maruti employees have everything working in their favor and another company, say uh, Tata or Hyundai or any other company employees have certain issue, just to show solidarity, they will go out and carry out a strike. But employer can take action, that is Maruti can take action against its employees, because in this case, when everything is fine from employer's perspective, just because another industry is uh, having a problem, the workers of other industry are having a problem, you cannot expect your employer to show solidarity to that. That is not his concern, especially in a profit driven model. So even courts will not recognize this kind of a strike. The next kind of a strike is stay in strike, or it is also called pen down or tool down strike. So recently, health department staff in the state of Punjab and the Ludhiana DC office, they carried out this kind of a strike where they will actually go to the office but they don't work. So this was in a decent mode where the staff were not getting enough salaries, or they were not getting timely salaries even in the pandemic when they were risking their own lives. So that is the concept of stay in strike. The next one is go slow tactics. The name itself indicates that go slow tactics means the productivity is X, but the employees decide that they will work at 1/10 of this speed. That is also a form of strike. The next one is hunger strike, and as long as the productivity is not affected, it doesn't really matter. It is just a moral uh, sign that the worker union or the trade union is showing to the employer. The next one is lightning strike. This is actually not recognized and it is unofficial. The trade union just walks out and starts the strike. It is not a legitimate strike. Picketing. Picketing is something that you've witnessed even in the independence movement. It is legal if it is not creating violence. It is a form of showing your uh, dissent to the employer. It is allowed, but it should not hamper the productivity and it should not lead to violence. The next thing is something that is defined in the Indian Penal Code. Gherao. Gherao is something where the workers try to block the employer or mid-level management and threaten him. So this is to safeguard the management from a hostile mob of workers. In this case, it is recognized in the section 120A of IPC as a criminal act. So this is prohibited completely as per the code. Finally, termination of service of the striking employee. If the process is not followed, he can be terminated or even blacklisted so that no other factory or no other company will actually employ him. Now we are coming to the important aspect of collective bargaining. The name itself indicates that when a trade union comes into the picture, it is legitimized by a law. Previously, there was just a process for trade union recognition as per this Trade Union Act of 1926. It was given certain um, rights like the right to strike, but neither the Industrial Dispute Act nor the Trade Union Act has given it certain legitimacy. It was not recognized. Only process of registration was considered. Now we have moved forward and given them certain rights. So the employers will be uh, also pushing for this collective bargaining by saying that if you work more, we will increase your wages or we'll give you better working conditions. So that kind of a model is called productive collective bargaining. This is from the side of employers. Now, who gave this term? This can be an MCQ question. It is Beatrice Webb for the first time in Britain in 1891. Just a trivial fact which can be asked in the question. Now, in order to have legitimacy for this collective bargaining, you have to have legal power. You need to have the right attitude. One of the stakeholders should not look at other as an enemy. They have to understand that they need each other. And the third one is a strong trade union requires certain processes and certain rules which this legal framework will create, but actual strength of the trade union will depend on the adherence to the code laid down as per the legal procedure. Now, this concept of collective bargaining is actually a fundamental right in the ILO convention. It is a legal method. So, what is the process? First, if there is an issue by the trade union, they will present a charter of demands. Please remember the flow of this. It can be a question again. There will be initially a charter of demands. If that is followed, then that is the end of the issue. You have a collective bargaining agreement, or the industry and the workers come together and decide we will resolve this issue through this legal agreement. That's it, end of the issue. But if it is not followed, what happens is simultaneously, one, a strike notice will be given, two, everything that is within the ambit of the stakeholders involved, whether it is conciliation, arbitration, that proceedings will begin. And after the award of either the conciliation or the arbitration, what is this conciliation arbitration? We'll just discuss. But let me tell you what it is. Basically, it is an adjudicating method where a third party will come and try to solve the issue, like, say, a third party conciliator or a judicial officer. What is the difference between this? I'll just tell you. After this process is given, the final step is written documents will be created, and the interpretation of this written documentation will finally lead to implementation of the new grievances which were addressed. That's it. That is the process of collective bargaining. Another trivial fact: how many trade unions are recognized as per the Labor Ministry? 12 is the answer. What is the most important one amongst them? A non political organization called SEVA, or Self Employed Women Association, which happens to be one of the largest women's organization in our country. We have discussed the levels of collective bargaining in the initial slides. What else do you have to remember? Another trivial fact: what is the first agreement that happened at unit or plant level? It is between TISCO and Tata Worker Union. Just remember this. The rest have been already discussed in the previous slides. Now, in the first video of this lecture series, we have discussed that any dispute between the workers and the employer will be solved by an adjudicating partner. Normally, the government will be a stakeholder in this tripartite agreement. So, depending on judiciary is a wing of the government. Depending on judiciary is creating a lot of burden on judiciary because of the already pending cases. So, you create an alternative dispute resolution mechanism where negotiation, mediation, conciliation, and arbitration are the various methods. You just have to remember that negotiation and mediation are informal in nature. Don't get into the details. The conciliation and arbitration are formal in nature. Conciliation is not binding, but arbitration is binding. These are the facts that you have to know. Another important point: The Arbitration Conciliation Act of 1996 is not applicable here. An important point. So why it is not applicable is not important here, or the legal reasoning behind that is not important because this is an MCQ question. So, however, despite the fact that it is legally binding, one can appeal in the court, but practically, if you do that, again you will be going back to the judiciary, which defies the very purpose. So, most of the times it is binding, or both the parties agree to the award given by this arbitrator. So, finally, the collective bargaining agreement is made, it is interpreted, enforced, and then you have a new contract. So, that is the process. The last fact that you have to note is there is also a provision for the creation of an industrial tribunal either by the state or the center. At the center, you have the National Industrial Tribunal, where decisions are based on consensus. This is an important point. Not by majority, but by consensus. If there is no consensus, another judicial member will hear this case and then take a decision. So, what is the composition of this industrial tribunal? You have basically two members. One, you have a judicial member, and two, you have an administrative member. If the National Industrial Tribunal is considered, the administrative member should be a person who occupies or has been a officer who held the rank of secretary level and above. And similarly, if the judicial member is concerned, he should have been or should be a high court judge. At the state level, or the bodies which are set up by the Center for the States, then in the case of that, administrative person should be of the level of joint secretary, either at the state or at the center, and the judicial member should just preside over this industrial tribunal. He should just be a judicial member, but he will preside over that tribunal. So these are all the facts that you have to remember from the industrial code. I'll be posting this in t.me/Hindu highlights, the Telegram channel. If you like this, please like, share, and subscribe. And you can also find the PDF of this document in this Telegram channel. So that's it for now. Thanks for watching.